Hello, everyone. Welcome to Court with Krissy. We can all use a pick-me-up once in a while, and I've rounded up 7 quick court cases from 7 different courtrooms that can do just that. Be sure to vote for your favorite clip in the comments, and I'll do the same. I hope you like it. Court with Krissy is now in session.
We're ready.
Good morning. I'm Judge Chungin. We are here on People of the City of Taylor versus Jonathan Dixon. Good morning, Mr. Dixon.
Good morning. How you doing, sir?
Very well. And appearance, please.
Is that Jim's?
Is right.
And we have People of the City of Taylor versus Lavette Rice.
Yes, sir.
Good morning.
Good morning.
Good morning. I'm Judge Chungin. If I may have an appearance, please.
Good morning, Your Honor. Jeffrey Fant on behalf of Ms. Rice. We'd waive formal reading, stand mute. Ms. Rice is going to plead guilty to the amended charge of allowing an unlicensed person to operate a motor vehicle and to the amended charge of double parking. We'd request a $50 per month payment plan.
All right, Mr. Moody, can you step up?
Yes, sir.
This is case number 24057888701, People State of Michigan versus Terry Moody. Appearances, please.
Good morning, Your Honor. Good morning, Counsel. Samuel A. Wagner, 23-157 on behalf of the people.
And Lorena Bijan on behalf of Mr. Moody, he stands mute, understands his right, and waives the formal reading.
All right, court order not guilty plea on behalf of Mr. Moody. What's your bond recommendation, Mr. Ragnar?
People are asking for a $10,000 cash surety bond to be able to post a bond. We're asking for together with home arrest. He has 2 other police assault cases that are open, I believe. One 627, well, 627-24 is this case, but 619-24 as well. So he has 2 cases open. He's got a previous police assault conviction back on 9/1/22. And he's got a robbery unarmed conviction 4/28/21 that I believe he's on probation still. And he's got a CSC conviction 11/28/01, CSC second, Your Honor. But a number of problems with the defendant continuing the same type of behavior with police officers and not listening to their demands. When they see him walking on a freeway, which they've known about him doing this in the past. They knew him from previous encounters, and they said there was a warrant out for his arrest from 2022. Subsequently, he was on a concrete barrier on the freeway, jumped, he started running, then jumped a fence. He's just, Your Honor, I believe he's a danger to not only the police, he comes in contact with, which he shouldn't be, but because of that, I think he's a danger to the public as well. He has a that's all. We think $10,000 cash surety tether home arrest.
Okay.
Thank you.
Okay, Ms. Bijan.
Yes, Your Honor, we are gonna ask for a personal bond in this matter. We're gonna object to tether the home arrest. My client is 29 years old. He is working right now in mobile retailing. He works every single day of the week, Monday to Sunday, 9 a.m. to 6 p.m. He did turn himself in, Your Honor. He is here today. This is a case where my client was found walking on the freeway. I don't see any reason to have the tether house arrest. As I mentioned, he's here today.
I'm sorry. Who are we doing right now?
Mr.
We're doing a
Mr. Moody,
walk-in. We're doing a walk-in right now. Then as soon as we get to the walk-in, we'll go straight to DDC. Thank you,
Mr. Moody, I
sorry.
need you to stand mute, okay? As mentioned, Your Honor, we are asking for that personal bond, and we do object to tether and house arrest.
Okay, court has heard argument as to bond. Mr. Moody, if you had not walked in, I might have given more weight to.
He's gonna have to speak slowly and really enunciate for me to hear what he says.
I said it is Satan, Antichrist. AR.
That's better.
Hey man, God bless y'all, man.
When we're on the record, Mr. Davis, I have to write down everything you say. So that's why I need you to go slow and get it so I can get it down.
And Jesus is the truth. Jesus Christ is the way. Nobody goes to God, the Father, except through the Son, and that's Jesus. You get that?
Well, I'm not writing it down yet. Not till the judge tells me to.
Oh, okay. Well, man, you know Jesus is the way, man. Jesus is the way, man, the only way, man. This world's coming to an end, man. You got to decide, man, who you gonna follow, man.
Mr. Settles, are you ready?
Yes, I am. Come on.
All right, this is People versus Miles Shively, file 2259 of 2024. Good morning, sir. And Mr. Settles is here on the defendant's behalf. This is the date for sentencing on the defendant's conviction of indecent exposure. Mr. Settles, have you gone over the report with your client?
Yes, I have, Judge.
And is it accurate? and
Yes, it is,
complete?
Judge.
Then what else would you like me to know?
Judge, I have reviewed the recommendation with Mr. Shively, and I believe the recommendation is appropriate. If I'm reading the recommendation right, the facts of the offense are extraordinary, and I maybe had this one time before, long time ago. And this is a case where Mr. Shively's he's been maybe addicted to methamphetamine, he's in felony probation, and he's not taking drugs, hasn't taken drugs in a year, and like whack-a-mole, I think maybe Your Honor is familiar with this. When this happens, although I don't see any alcohol in his past, it looks like whack-a-mole, he's not taking the drugs, and so the brain it goes over to this alcohol. He knows he shouldn't be drinking, it's a violation of his felony probation, but he does that. And he does that in such a manner that he blacks out. And when he blacks out, he's doing things that are certainly not appropriate. And Judge, he spent 72 hours in jail on his upstairs, the felony. He was not, I don't know if he was violated. I think the PO just put him in jail for the 72 hours, although he did visit the judge. I don't think the judge, Elsenheimer, did anything. Told him good luck, his issues are going to be down here with Judge Cooney, and here we are. And Judge, from what I'm looking at the recommendation, it appears as though the recommendation is saying that he is on felony probation now, and he is being monitored by that. And I would ask the court to consider a time served case for this and to close the file, if you will, and let him negotiate this through the felony probation. He is ashamed. When I talked to him about this case, I sent him the police report. He didn't. Before he saw the police report, I don't think he understood because of the blackout what was happening. When I talked with him, he was shamed, definitely shamed. That was the word for it. This was not something that I sensed that there was some mental incapacity. No, I think it's a blackout drunk. And sometimes in that blackout stage, things happen. Weird stuff happens. And I'd like to say there was no victim, but at the same time, I walk around the Boardman in that area with my kids and stuff. So, and I love Traverse City quite a bit, and I hate to see these things happen, but nonetheless, He's a young kid. I think that he's ashamed. I don't think we're gonna see this again. Oh, his counselor has recognized that whack-a-mole theory is not taken meth, so now they're treating him for that also. And so I think he's in good hands. I know he is remorseful. More important, what I have to say, I think we should be addressing this. Thank you.
Okay, thank you. I would like to hear from you, Mr. Shively. Anything else you'd like me to know?
Yeah, Your Honor, I understand what I did and I'm not avoiding responsibility for my actions by any means. I'd just like to continue as much as possible forward in the right direction and tackling sobriety with alcohol is my next feat. I'd like to continue my year cleanliness from controlled substances and that such. So I appreciate you for your time.
All right, thank you. So this is sentencing on the defendant's conviction of indecent exposure. It was originally charged as a felony aggravated indecent exposure and habitual offender second offense. The facts are the defendant was exposed and masturbating in front of an elderly couple on the Boardman Lake Trail, a trail that I frequently use, and a trail that not too long ago I wouldn't take my family down, frankly. And it's because of behaviors like this. So the defendant has a long prior criminal history. I noticed the first two in 16 and 17 were unsuccessful probations. The defendant was on felony probation at the time this occurred for possession of methamphetamine. That was in 2023. And so while he's on felony probation, he's out masturbating on a public trail. So, and as far as I know, this was during the daytime. There was no reason. The defendant himself tried to explain he was sunbathing, but he was also looking at revealing pictures of women on his phone at the same time, but denies that he knew what was going on. So the fine is going to be $100, costs are $300, 75 crime victim, 50 judicial system fee. There's a $700 court appointed attorney fee. I agree, there's no point to probation in this case because the defendant is going to continue on felony probation for the next year. But the sentence is going to be 30 days in jail, no credit for time served. And that is because of the prior record, the facts in this case, and frankly, I think the defendant has, I don't think he has apologized. I don't think he's made up all kinds of excuses, not knowing what was going on or being blacked out, and I don't buy it. So that's it.
Thank you, Aaron.
I think I'm all done.
Do we have Mr. Klein?
Should be a Clayton Klein.
Oh, see, oh, okay. And I was going to tell you right off the bat that Mr. Klein had significant hearing issues. Apparently, either he does not have with him or they will not give him out of his property his hearing aids. I'm not sure which it is.
Okay. So we are on the record in case number 24-2379FY. You are Clayton Klein and you're appearing for arraignment purposes on an allegation of a bond violation. You're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Council, here to assist you. Ms. Mistley, did you have opportunity to review the allegations on the bond violation nature of the same with Mr. Klein?
I did, and he would like to exercise his right to a hearing with Mr. Connolly present with him.
Can I make a comment? You told me to talk to my attorney and get their phone number. So you get the phone number and you can get prescription drugs cheaper. You can get a free wheelchair. You can get a free watch with this, that, and monitor, and they'll send it directly to your house. there's, I even asked the officers to get back on the computer, make sure they have the right number. So you call it back again. And if you're over 50, push pound. If you're under 50, push 1. And you get a free walker and you get a free wheelchair. And
the police officers will make sure to give you Mr. Connolly's correct phone number.
I'd be appreciative, ma'am.
Do you have something to write with right now?
Yeah, we do. Well, the officer here does. Kapala does.
It's 231.
Right, thanks, thanks, ma'am. On the computer, it gives you a 9329.
Okay, I don't know.
So it's all good. At least we got it.
Okay, so Mr. Klein, the hearing will be scheduled as quickly as possible and that you will remain incarcerated between now and the time of the hearing. We'll certainly let Mr. Connolly know. I want to make sure that you understand no contact is in effect even though you are in jail. I believe that we went over that at the time that the bond was set. So no contact means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with the alleged victim in this case, who is, so you cannot use another inmate's phone or phone privileges or pass any messages, have anybody make contact for you on your behalf. No contact means exactly that. So do you understand that?
I understand she's my attorney, and I understand she's dealing with my mom, Commission on Aging too, and I understand she's my attorney, so I don't comprehend how I can't talk to my attorney. I really don't understand that. If she is my attorney, as well as my victim, how I can't talk to my attorney, but I do understand what you're saying to me now. I do understand what you're saying to me now. I do understand what you're saying to me now, but even on my bond paperwork, it doesn't have my bond on there. It doesn't have anything, no conditions, no nothing on it that I got from these guys. Nothing. So quite truthfully, I didn't even know. I couldn't even hear you the first time. The volume was low. I tried to tell people that.
Well, we talked to each other and you answered questions. So we have the video of that. I believe that we did go over that very carefully, but you need to talk to your attorney. The hearing will be scheduled as quickly as possible. So I just want to make sure that you understand what the conditions are with regard to the no contact.
I got you now, ma'am, loud and clear. And that can go on record.
Okay,
I actually do understand to hear you.
Thank you. You are all set.
Working now.
Why is that camera so yellow?
Jaundice. It has liver issues.
I was just thinking, do I have?
All right. Okay. Who is in Polk County? I don't recognize you.
Joseph Collins.
Oh, Mr. Collins, I haven't seen you in a long time.
Yeah, I've been trying to be good.
Oh, I'm glad to hear that. I will get to your case in just a moment. We will go on the record in the matter 24 CF 175, State of Wisconsin versus Joseph Collins, and 24 TR 766 and 765. Mr. Collins appears by video conferencing in custody at Polk County Jail. We have Assistant District Attorney Kevin Schmidt in person. We're set today in this matter for an initial appearance. Mr. Collins, did you apply for a public defender?
No, I did not.
You did not. Why did you not do that?
I don't know. I don't know.
Are you on a hold or are you on a revocation?
I'm on a 90-day sanction through my PO. Other than that, I'm on a $750 cash bond from you guys as well.
Right, but my cash bond means nothing because you're on a 90-day sanction, right? So it doesn't even matter.
Right.
So when are you looking at the sanction being lifted?
It was October 17th.
So you're there at least until October 17th. All right, so what I need you to do, Mr. Collins, is I need you to call the public defender's office and I need you to apply for their services, okay?
All right.
All right, because we can't proceed with the initial appearance until that's done. I mean, we can with you without an attorney, but I'm gonna presume because this has a few felonies in here, you're probably gonna want an attorney. So I'd apply for a public defender and then we can get you back in here for an adjourned initial appearance. I'll give you a little bit of time to be able to do that. I can set you for an adjourned initial appearance for September 11th at 2 o'clock, okay? September 11th at 2 o'clock. Please call the public defender's office like immediately, right away, so that they can work on getting you an attorney, okay?
All right, thank you.
All right, thank you. We are adjourned.
Gage April, Your Honor.
All right.
Present.
Court will start with State of Kansas versus Gage Douglas April, case number 2024 CR 341. Amber Norris appearing for the State of Kansas, Gage April appearing from the jail Zoom location. Mr. Watts, I think this is your case. Jim?
May I?
Yes, sir. Judge, I don't have that file with me. I think it may be Joe's.
I don't have any appearance from him. The order of appointing is for you. That's what I was going off.
It's Chris Pate's brother. Yeah.
I will get a hold of Chris and see where he's at.
And see where who is?
Chris Pate.
Oh, I see. Okay.
May I ask a question, Judge?
You may.
Okay, I'm not quite sure where this is going at what point in time, but for my own safety and sanity, if that's still of matter, I would have liked to have requested far before being placed in jail, that I would have been put in some sort of a witness protection somewhere away from the state of Kansas, as I've been fearful for my life for years now. And so, I mean, just to be here in front of a judge and finally have a camera and be on a court docket, I can't believe that it's taken this long. I've been on the Kansas Missing and Exploited Children's list since I was in elementary school. And I have no parents. My grandparents have passed. I have no family.
Okay, you're an adult now, Mr. April.
Correct.
Okay.
And
you say a witness protection program, that would be a program that would be essentially set up by prosecutors, not a judge.
Right.
And that usually would be based because you have witness information against others. So, I mean,
That's
don't
not
make light of what you're saying, but I don't know if that's something for the state district court to be addressing here, Mr. April. What I really want to address here is the status of your current case before this court. And apparently, Chris Pate was subsequently appointed after Mr. Watts was initially appointed. So there is a new attorney in your case.
Right. I don't have a record if that's where we're going with that. So I may be a grown adult now, sir, but I didn't get here by happenstance. I'm a survivor. I'm 6 years sober. I'm not trying to collect names so that I can collect a check and skip to another state. I'm from Butler County, born, bred, and raised. I'm not saying that proudly all the time. I'm just asking for a chance.
I'm not able to take your call right now. Please leave me a message and I'll get back to you as soon as possible.
when you have finished.
And Your Honor, I don't know I don't actually have a copy of the filed order appointing. But the one that we had for Mr. Watts was file stamped July 23rd. It's, August 12th. I'm not sure whether or not he would have gotten it in time to get it on his calendar. Like I said, I don't actually have a file stamped copy of the new order that appoints Mr. Pate.
I was in contact with him. He knows of it.
Okay, so has there been a formal order appointing Mr. Pate?
Yes.
Okay. It could be in the electronic filing system somewhere. All right. I hate to attempt to try to schedule any preliminary hearings without defense counsel's calendar being involved. But that is one essential purpose of this docket. If the case isn't in a position for prelim waiver, which certainly the court wouldn't be comfortable with, then an evidentiary preliminary hearing needs to be set.
Your Honor, if we could push this one maybe to the heel of the docket, and maybe we can get Mr. Pate in. I don't really want to calendar it and then do subpoenas, and then we would have to call those subpoenas off because the day doesn't work with Mr. Pate's calendar.
I am going to have you rejoin with video though, Ms. Norris. You're going to address the court very well. I tend to agree with your position though, Ms. Norris. Mr. April, we're going to recall your case later in this docket. It's a long one today. So we'll call you back in a little while and we'll deal with your case again, okay?
And then before I go, may I just, if I'm able to like survive and live another life, I don't want to die of a stroke in jail. Like I really am so unfortunate that this is a reality. And if I could wave a magic wand, I would redo it all. So just, I beg of everyone that can hear me, please give me a chance. That's all I have to say.
So noted, Mr. April. We'll call you later in the docket.
Thank you, Judge.
Judge, he is joining right now.
Do what?
Chris Pate is joining.
Okay, can we bring Mr. April back?
Did you get my message, Mandy? I hope you did.
No, I'm sorry.
Oh, yeah, I got stuck in a hearing with Judge Webster that ran long.
Oh, okay. I see it now. Sorry.
Sorry.
All right. Mr. Pate, we're here on this Gage April case, and we're trying to determine the status of preliminary hearing. Is there any announcement that you're ready to make at this time?
Your Honor, as I'm sure the court's aware, I was just appointed last week. I've not received discovery nor had time to get out to the jail to see Mr. Apple. I would request either a new PHC setting or a preliminary hearing that's out a couple of months to allow me adequate time, given the serious nature of the charges.
And because of the serious nature of the charges facing this defendant, I want to get an evidentiary hearing set on the calendar without any further delay. Counsel, I'm currently looking at Monday, September 30. Quite a ways out, Mr. Pate. It's at least 6 weeks. Monday, September 30 in the morning hours. Starting at 9 o'clock.
Is this in person or Zoom?
Does the state take a position on that?
I do not, Your Honor.
And I'm available either way. I'm not available in the afternoon, but I would be available the entire morning.
This is going to be an extended hearing on a Monday morning on top of the rather large misdemeanor control docket conducted at that time. The court's going to set this as an in-person proceeding. Courtroom B. Draper will need to be transported to courtroom B by court security. So it'll be an in-person proceeding starting 9 o'clock a.m. Monday, September the 30th. I'm going to go ahead and mark out the entire morning for this. I don't know how many witnesses will need to be called. Monday, September 30, 9 a.m. for a preliminary hearing in this case. That is obviously an evidentiary setting in person. With that established, Mr. Pate, anything else we need to address currently on him?
Not at this time. Just Mr. April, I'll be out to see you before that date at the jail.
Sure.
Right. Ms. Norris, anything further on the April case?
No, Your Honor. Thank you.
All right. The April case is currently in recess. We'll move on to another matter.